disposed of either by agreeing to add the phrase about authorizing the mayor to sign the agreement or not, then the main motion is back up for discussion and action. Another motion that's often made is a motion to close debate. The actual wording in Robert's rules for that motion is, I move the previous question. But most people simply say, I move to call the question. And reasonable interpretation from a parliamentarian standpoint is that either motion is adequate to bring to the governing body or the board that action to call the question. The motion must be seconded, but it is not subject to debate or discussion or amendment. When you get a motion to close debate, everything stops until there's a vote. No discussion, no amendment, it's voted on. A motion to move or call the previous question must be adopted by a 2/3 vote of all council members present. So if there are all 7 of you present, that vote takes 5 yeses to be adopted to stop debate. And if that motion is adopted by that 5 votes, then the debate is stopped and the council needs to immediately move to vote on the motion. If the motion to call the question is not adopted, in other words, it gets just 2 or 3 votes or 4 votes, but not 5 needed, then discussion on the main motion continues as before, and you just keep on going until that motion is disposed of. Another common motion is a motion to table. Robert's rule says that motion should be, I move to lay the question on the table. But again, it's often worded more simply, I move to table the motion. Like the motion to call the question, this motion is not subject to discussion or debate or amendment, but it has to be seconded and then is to be voted on immediately. A motion to table is adopted by a majority vote. So it takes 4 votes to adopt a motion to table. And if the motion to table is adopted, the consideration of the item at that meeting is over. The subject can be placed on a future agenda. Another typical motion is a motion to postpone. Very similar to a motion to table, but the motion to postpone is, I move to postpone the motion to the next regular meeting of the City Council, or to a specific date that the council is going to be meeting. If seconded, a motion to postpone may be discussed. It may be amended. Someone might want to say, well, let's not do it at the next regular meeting. Let's do it at the next meeting, whether it's a regular meeting or a special meeting, for example. The motion to postpone, like the motion to table, is adopted only by a majority. It doesn't need a supermajority of 5 or more votes. And if adopted, the motion to postpone is placed on the agenda in accordance with the wording of the motion, whether it's the next regular meeting, the next special meeting, something along those lines. And then the last motion I wanted to cover is a little bit more dramatic. It's a motion to kill the main motion. And the wording for that motion is, I move to postpone the motion indefinitely. If seconded, this motion may be discussed, but it may not be amended. You're either going to kill this or you're not going to kill it. A motion to postpone indefinitely is adopted by a majority vote. And if adopted, the matter is not to come back. That ends that motion essentially forever. The way people get around that is to find another motion that's close to it and deals with it. The motion to postpone indefinitely, I've only seen work once. A board I was on was debating changing the name of the organization. And the name had been used for about 95 years. And somebody wanted to change the name, to modernize the name. And someone else on the board said that he wanted to move that to postpone the motion indefinitely. And it was adopted. And there's never been another debate on that board in the following 30 years or so to change the name of the organization. I referred earlier to the Open Meetings Act, and I want to spend a few minutes talking about the Open Meetings Act, and this may be directed most to our newest members, I think Ms. Street and Ms. Grider, because there's a training video, and if you haven't seen the training video from the Office of the Attorney General, please do so. The state law requires that be done within 90 days of taking the oath of office as a member of the governing body. It's only about an hour long, and Patty can give you either the link, or sometimes years ago when they first did it, they actually sent out DVDs to cities, but you can certainly go to the Secretary of State's website and find it and watch it, and then print a certificate of completion that should be turned into the city secretary.
Mark, I don't mean to interrupt you, but don't I need to redo that as well?
My position in the Office of the Attorney General seems to agree that once you do the video once, you do not have to do it each time you're elected or re-elected. Anyone is certainly welcome to just watch it as a refresher. It's like chicken soup, that can't hurt, but I would say that you're not required to take it but one time, to watch it one time. But please make sure that a certificate of completion is turned in to the city secretary. We've had, in another city I represent, there was an open records request for copies of those certificates. So make sure Patty has them.
Thank you, Mark.
The notice of a meeting, this agenda, which there seem to be a few extra copies of, this agenda must include, as this does in the caption, the date and time and place of the meeting. Saturday, May 15, 2021, 9 o'clock a.m., City Council Chamber, 112 Bound, Kirby, Texas. If that information is not on the agenda, then you're not going to have a meeting. And the agenda does need to include, in addition to that basic time, place, and date information, the subject of every item that is going to be addressed at the meeting. If someone wants to talk about something that's not on the agenda, they can do so, as the citizen who spoke a few minutes ago did. They can talk about anything they want, whether it's an issue on their street, whether it's an upcoming event, whether it's a variance that they don't want the council to grant next week. All of that can be spoken to at this meeting during citizens to be heard. The meeting next Thursday night, there'll be a public hearing on the variance that was discussed in citizens to be heard this evening. And so citizens, whether it's Ms. Darby or others, will be able to come and let the council know what their view is on the item before you during the public hearing. In citizens to be heard, the most important advice I give city councils is one word: listen. That's the purpose of citizens to be heard. We ought to listen to what's on the mind of your constituents and other people who are interested in the affairs of the city. Answers should be limited. They can include only two things: facts or policy. There should not be a debate. Often the presiding officer, the mayor, will refer a citizen to staff to follow up on something, or will ask staff to follow up with the citizen at a later time. My recommendation is that only the mayor should respond for the governing body during citizens to be heard, and only the city manager, or in some cases the city secretary, for staff. There may not be under the statute, discussion by the city council on the merits of what was discussed. You can briefly discuss whether to place the item on a future agenda. There cannot be a motion to do that. There can simply be a discussion. Ms. Grider could say, I'd like to have that on the next agenda. The mayor will say, thank you, and we'll see about that, or words to that effect. There should not even be extended discussion about that. But that is the only kind of discussion there might be. You may have heard, and in the video they have a little thing about walking quorums. This is a very somewhat complicated issue that was in the federal court system about a year and a half ago. about walking quorum. The Open Meetings Act says that it's a violation to participate in a walking quorum. And a walking quorum violation occurs when one member of the governing body knowingly engages in at least one communication among a series of communications that each occur outside of a meeting concerning an issue that's before the governing body, and in which the members engaging in individual communications constitute fewer than a quorum, but the total of those communications do constitute a quorum. One councilman talking to another councilman, not a problem. But if both of those council members then talk to a third and fourth council member, all four have committed a walking quorum violation of the Open Meetings Act. And there's a presumption of sorts that when members start that process of conversation, that they know there's a risk that it could involve ultimately discussions outside of a meeting with a quorum. The communication that starts the walking quorum can be a face-to-face discussion, it can be a telephone call, it can be an email, it can be a social media posting on Facebook or Nextdoor. And in one case, the walking quorum was based on, a walking quorum was alleged by a district attorney's office in Texas based upon emails among a majority of the city council about when to hold a special meeting. Not about the subject, just when to hold the meeting. And that was a court case. It was ultimately dismissed, but there were a lot of nervous council people in a small town because of that action. The short message is, do not discuss city business with other members of the city council in any way or format unless you are in this room during a properly noticed and conducted meeting of the city council like this one. You can have closed sessions of the city council. They're sometimes called executive sessions. The statute permits those in specific situations, consultations with attorney, personnel matters, some but not all real estate matters, some but not all economic development matters, and security matters. Those are the ones that are most typically the reasons for having an executive or closed session by city council. Discussions in executive session should be considered confidential. Revealing discussions